Hello everybody. We are here for the second time today, still trying to catch up on the very many court documents that I missed between 1 week ago and right now. There have been quite a few court filings, also quite a few public media interviews that we may even go over, particularly with Andrew Wallet. Hey everybody. Lara Croft Online. Hey, how are you? Natalia, how you doing? We're here for the second time today, and it worked out perfectly because the last document that we read earlier today was basically Jamie Spears saying he doesn't think that it's necessary to hire these litigators from that California firm. And this is actually Sam Ingham's response to that response. So it's kind of confusing because the title of this document is the same. It looks as though it's the same as that other document, but in fact it is the petitioner's reply, right? So petitioner's reply to, and then the exact same name of the document that we already read earlier today. So this is, for those just joining, we're about to get started for real. This is Sam Ingham, which is Britney Spears' court-appointed lawyer. Sam Ingham's response to Jamie's response to Sam Ingham's original petition, asking Judge Penny to allow him to hire some litigators to help him in case they need to go to trial over this conservatorship. I, as usual, have not read this document. I have seen a few excerpts from it on Britney Hiatus page and Lawyers for Britney, Meaner, but I have not read the document in full, so it'll be my first time doing that now. Okay, so petitioner in this particular document is going to be Sam Ingham. He is replying to Jamie Spears' response to, to Sam Ingham's petition, as we already established. That document was filed, Jamie's document was filed October 2nd, 2020, and he filed it as the conservator of the estate, and he, he's saying as follows. So Sam Ingham's saying, I'm going to lay some facts down for context, but you should already know this. So procedural background, that means like the history in the court, right? How did we arrive here? Well, here, just the footnote too. If you're somehow still here trying to learn how to read legal documents, I really commend you. But you always want to read the footnotes. So for convenience, this pleading, that means this document, will refer to members of the Spears family by their first names. No disrespect is intended. Because we see in Geraldine and Gerald's writings, they say Mrs. Spears, Mr. Spears, and it actually gets quite confusing, even if they do it the right way. And as we saw in a document earlier, they even got mixed up themselves, and they called one of the documents Miss Spears, they called one of the documents Mr. Spears' objection to such and such, when in reality that was actually Miss Spears. It was Britney's objection they were actually referring to, which makes things very confusing. So I appreciate this legal writing style that Sam has adopted, where he refers to people by their first name. I think it's much less confusing. Good job, Sam. 1 point, Sam. All right. So here we are with the procedural background. The procedural background is Sam Ingham had filed a petition for an order from the judge, which would allow him to associate litigation counsel. That's that firm Loeb and Loeb. And that is set forth for hearing on October 14th. They're calling that, Sam Ingham is calling that particular petition the associated counsel petition. Someone said, Free Britney 02, so excited for this. Ingham ending careers with this filing. Oh, good. Oh, is this a good one? He started with 1 instead of 2. Oh, right. Exactly. Yes. Yeah, exactly. Sorry, your name is all 1 and I can't tell where it ends in. Marek Walsh. I'm going to go with that. Yes, exactly. Look, we can see here Sam started with the number 1 instead of the number 2 in his section, just like you're supposed to do. So we're already doing better than Gerald and Geraldine with the formatting. That is a very good catch. All right, so let's get going with this. People seem excited about this one. All right, so that particular petition is set for hearing on October 14th. It's coming up soon. The minute order of this court, that, you know how you'll see the things that say like, oh, you know, it's just like a very, very short little summary of the court date that always comes out very shortly after the hearings. That's called a minute order. So he's saying the minute order from the August 19th court date provided that any objections need to be filed by October 2nd with a response to be filed no later than October 6th. So basically Sam is saying, you told me that I had until October 6th to respond, and in fact, if you look at the date that this was filed, it was filed on the deadline, October 6th. There's nothing wrong with that. That's actually pretty common. Most lawyers will do that. They will wait till close to the deadline to file, if not wait till the deadline itself. James has apparently filed a response in lieu of objections. Therefore, petitioner offers the within reply in lieu of a response. Okay, so basically, Jamie was supposed to have filed objections by October 2nd, but instead of an objection, he filed a response. And they can kind of operate as the same thing, but technically speaking, if the judge tells you you have to, a certain time to file objections and you don't file an actual objection, then it could be considered that you didn't object. It could be considered that you're not necessarily, against what that particular person filed. So I see why Sam is playing these word games here, but I think that a judge may be forgiving of that. So Sam is saying, since he didn't file objections like he was told to, I don't really know how I'm supposed to file, a response. So instead of, a response, I'm going to just do this reply. So he's calling this a reply instead of a response, which I don't know. It's kind of a little bit belabored, but that's fine. I guess it's possible it's necessary. I don't know. So introductions. Although its tone is conciliatory, the response, so when he says response, he's talking about Jamie's document that we just read, right? Where he says there's no really reason to allow Sam Ingham to hire these expensive lawyers because, first of all, they're too expensive, and second of all, we should be allowed to all sit around a table and have a meet and confer first before we, decide what to do with these lawyers. And the third reason they gave was that it was just unnecessary now because they had withdrawn their Andrew Wallet reappointment petition, right? Remember when they were trying to get Andrew Wallet to come back? Well, the last document that we read is this response. And that very exact response said, we withdrew Andrew Wallet's candidacy. We should all be allowed to sit around a table and talk about a fiduciary without the court getting involved, and the court shouldn't even worry about these other lawyers. Okay, so that is the document we're talking about whenever we see the word response. So Sam is saying that response is more notable for what it doesn't say than for what it does. Okay, so let's see what Sam thinks it's weird that document doesn't say. First of all, the response doesn't constitute objections to the associated counsel petition. In fact, it doesn't raise a single legal argument against it. And I can't exactly say for sure if that's true or not. I can't remember everything it said, but it did seem as though they were just saying, oh, it's not necessary anymore. So if that counts as a legal argument, I guess that's fine. What else? It doesn't consent to the appointment of Bessemer Trust. And if y'all will remember, that was something that I was concerned about. I was like, they keep saying oh, we should all get around and agree on this corporate fiduciary. We should all meaningfully in good faith discuss Britney's desire for a corporate fiduciary. But they kept just saying a corporate fiduciary. They didn't say we consent to Bessemer and we will work with Bessemer as a co-conservator. No, they're just saying a corporate fiduciary. So I'm glad that Sam pointed this out because it was something that I noticed as well. And I think Leanne also said that she had noticed that as well. It doesn't consent to the appointment of Bessemer, the fiduciary nominated by Britney as conservator of her estate. And also it was nominated by Lynn Spears, if you will remember as well. Third point, it doesn't consent to the appointment of any corporate fiduciary as conservator of her estate. That's true. They don't consent to that. All they do is say a good faith effort should be made to have a meet and confer and let's talk about it and push off your decision for 4 to 6 weeks. So they just want to keep collecting their fees and sitting here not doing jack for the next 4 to 6 weeks or however long after November. And Sam's about to say, no, that's not going to work, buddy, because you didn't even consent to the appointment of any corporate fiduciary as conservator. And look, again, whoever it was that noticed, oh man, I'm sorry, I don't remember who it was, but somebody noticed that the response that we read earlier kept saying, oh, corporate fiduciary as co-conservator, as co-conservator, as co-conservator. And somebody was like, it's really cute how they keep saying co-conservator. Like, we're going to have to wait until Sam more directly says, no, Jamie's going to have to just leave. We're just going to have one conservator. And this is another hint that that's what Sam is going to do, because he's not saying co-conservator. He's saying she doesn't consent. The response doesn't consent to the appointment of any corporate fiduciary as conservator of her estate, not co-conservator, right? Y'all notice that little tiny subtlety? And last thing, it carefully avoids calling this was the title of that document that Britney signed, nomination of conservator, right? It was signed by Britney, and he's saying, Sam Ingham is saying, their cute little response very carefully avoids calling the document exactly what it is, a nomination. They refer to it clumsily and inaccurately as the consent to the appointment of Bessemer Trust bearing Britney Spears' signature. This circumlocution signals that James wishes to preserve his ability to litigate the validity of the nomination later whenever he chooses to do so. So this is a fancy way of saying, the reason that he's doing all of this is the reason he has avoided calling it a nomination is because he doesn't want later, whenever we're litigating, whether or not Britney is even validly able to. Sorry, I got distracted by y'all's comments. So basically, Sam Ingham is saying, they're calling it the consent to the appointment of Bessemer Trust. That ain't even the name of the document. The name of the document is the nomination of conservator, right? That was the name of the document. And Sam Ingham is saying, and the whole reason that he's doing that at all is because he sees a trial coming in the future over whether or not she's even able to nominate a conservator. So basically, Sam Ingham is seeing the writing on the wall, and he's saying, no, baby, we need these litigators. And look, they are keeping their options open to litigate. So that's why we need these people who are good at trials. 3, further meet and confer, not productive. Okay. I'm glad he's raising this too, because remember, I raised it in the last video. They had tried to go on these meet and confers before. And if you weren't on the last video, just to remind you, what a meet and confer is basically where lawyers and clients get together and talk about the merits of the case and kind of try to come to an agreement of sorts outside of court, even if they can only agree on a few things, like see what they can possibly agree upon and come together on some kind of agreement. Now, they have already tried to do this in this case a few times, and I anticipate that Sam's going to bring that up here. So he says, the response, which is that document we just read, the last video, proposes a, quote, meaningful, meet and confer with, my highlighting's not working, sorry, we're up here. A meaningful meet and confer with Britney, right, and Mr. Ingham, which is her court-appointed counsel, to explore the issues facing the conservatorship and the specifics of this modified structure of the estate. So basically, that was Jamie's lawyer saying, no, we need to all get together, meet and confer, talk to Britney, talk to Mr. Ingham, and explore the issues facing the conservatorship and the specifics of the estate. But Sam is saying, however, before the petition to appoint Bessemer Trust was even filed, counsel for Britney, which is Sam Ingham, the person writing this particular document, instigated and participated in 2 separate, meet and confer sessions. So he said, I already asked them to sit here and meet and confer. We already did that. The first one with James's lawyers was a phone call, and that was supposed to resolve a simple dispute over one sealing motion. The second, quote, meet and confer, was an all-day session before Aviva K. Bob, which is a retired judge. a distinguished settlement officer respected by both sides to resolve the dispute over the appointment of Bessemer Trust. Oh, he's spilling some tea. We're getting some secrets. He's now telling us that the reason that they had met and conferred for that all-day session, remember whenever he referred to this all-day meet and confer session in his very first opposition to sealing the record, he referred to an all-day meet and confer with Judge Aviva K. Bob, but I don't remember him saying exactly what the reason for that was. Now he's saying, we already met to talk about the appointment of Bessemer Trust. It was useless. We spent all day, every one of us was in there, using all of our hours, billing up all these fines and fees for nothing, for no reason. And now they're telling us they want us to do the same crap all over again. No, Judge, don't listen to them. That's what Sam is saying. In addition to all the lawyers, James participated personally in that meet and confer, as did Britney's mom, Lynn, with her lawyers, okay? Both sessions were completely fruitless. That means useless. Nothing came out of them, with no agreement reached on a single issue and no request by either party or any party or by the judge, Judge Bob, for further sessions. So basically they got together, they met in front of a retired judge to try to settle their issues, to try to get to the bottom of whether or not Britney could nominate Bessemer Trust, and they weren't able to come to any conclusion. And now Geraldine and Gerald, who are Jamie's lawyers, are wanting to do this whole circus all over again, pun intended. There is no reason whatsoever, Sam says, to believe that a further meet and confer session will produce a different result. They will simply generate additional cost, which James is, ostensibly, which means allegedly, trying to avoid, all of which will be borne by none other than Britney, right? Okay, so now he's on to his fourth point, wherein he's going to say, he's going to argue against, hold on one second, y'all. Sorry, 1 second. Which one are you looking at? Oh, right. Got it. Okay. Sorry, y'all. Multitasking. I'm not great at it. Okay. So, right. So a lot of times these meet and confers, just to wrap this part up, they will look like what's kind of called like an arbitration or a settlement meeting. And like a judge will kind of like go back and forth between two closed off rooms, right? Like this is how arbitration or mediation, not arbitration. Sorry. If lawyers are here, I know I said the wrong word. Mediation. Mediation is where like there's a retired judge and it's kind of like I imagine it like those old episodes of Scooby-Doo, if y'all are old enough to remember that, where like there's like, this one judge, he's retired and he's like running back and forth through the hall, like to different rooms, like the different parties. And he's telling them like, your case is strong because of this and it's weak because of this. It's strong because of this and it's weak because of this. And then he'll go over to the other party and basically try to tell them like what their weaknesses are going to be at trial and in court. And it could be that this thing with Aviva K. Bob, who is a former judge in the California probate system, was doing that type of a thing, like an arbitration. And those are actually like a lot of times really good if you have a good, judge. But it seems like they already tried to do that twice, once on the phone, once in real person all day in that session, and it just didn't work. And honestly, like, I think that's true. I think that sometimes it just is in the best interest to just go to court because both parties have their own sides. They hate each other. They're not going to compromise and they're going to, just basically not do anything that's nice for the other side. And they're going to just continue to prolong the inevitable, which is a court telling them what they have to do, right? All right, so now we're going to look at this very short section, the petition not moot. If you remember the last document, the response, the one that was filed by James, they said that the petition to seal the record and all of that, it just should go away. It should just be dismissed in general because we're no longer using Andrew Wallet. I shouldn't even be recapping. I should just read this because it's right here. But they say that petition to keep the record open or whatever should allow, let's just read it here instead of me, because I'm getting, remember even those telephone calls they made with each other gets them money. Right. Every single telephone call gets them money. Every single page they write, every single sentence they write, every single paragraph, every single thing that they do makes them money. Going to a mediation session gets them money. Showing up at trial gets them money. Everything. So if they want to kick it off 4 to 6 weeks, every email they send in the meantime is going to make them money. Every one of these documents they write, every phone call, every text message, they're going to make money in those 4 to 6 weeks. Okay, let's get back to this. Okay, the petition is not moot, Sam Ingham says. Moot means like unnecessary, right? No longer necessary given the current state of affairs. The response, which is Jamie's document, makes much of the fact that Jamie has withdrawn his petition to bring back Andrew Wallet. So Sam Ingham's saying, yeah, they make a big deal about the fact that they've withdrawn that petition. But and they say, as a result, there's no longer any urgency, and James therefore requests that the petition to associate the new lawyers should be denied as moot. So that's what they said, right? Okay, well, we withdrew our petition for Andrew Wallet, so y'all don't need lawyers anymore, right? That was their argument. And therefore, his little request for lawyers should be denied because it's not necessary to litigate anymore. Sam comes in and says, this request assumes that the only... Yes, oh my God, this is so funny. If y'all go watch the last video and then watch this one, I anticipated so much of this. I'm going to be such a good lawyer even if I failed the bar exam. Sam says this request makes an assumption, and that assumption is that the only reason that we might want to litigate is to contest a petition for Andrew Wallet. Basically, knock, knock, we might want to litigate some other stuff, y'all. However, Britney will still need litigation counsel to pursue appointment of her own nominee, Bessemer Trust, right? This may not be urgent to James, but it is certainly to Britney. Despite his effort to appear conciliatory, which means like to look like he's playing fair or operating in good faith, right? Despite his effort in his, response to look like he's trying to, be nice and play nice, nothing in his last, submitted document assures that he will ever agree to do anything other than nothing in the response assures that James will ever agree to do anything other than talk. That is true. The only thing he agrees to do is go to a meet and confer. It's true. As noted above, James can't even bring himself to concede Britney's ability to nominate a top quality corporate fiduciary. So James can't even bring himself to say Britney is able to nominate a fiduciary. He can't even say that because he called her document a consent instead of a nomination. All right. Number 5, lower cost of representation. James cites the hourly rates of Loeb and Loeb LLP to argue that that hiring them is not indicated or in the best interest of Britney Spears. However, here we go. I've seen this one on Lawyers for Britney, so I know what's coming here. However, a quick comparison, I wonder what we're going to compare, shows that James himself recently used more attorneys at significantly higher billing rates to pursue litigation against a single individual represented by a sole practitioner. In Spears versus Lutfi, Jamie engaged a law firm called Sidley, which staffed the case with the following attorneys, to whom Britney paid over $300,000 in fees during 2019 alone. Chad Hummel, $1,170 per hour. Jack Yeh, also an attorney at Sidley, $1,012.50. Girl, they got to get their 50 cents an hour. I think this 50 cents is so stupid. Just make it a round number. Eric Schwartz, $814.50 an hour, and Gary Hirschfield, $486 per hour. So Jamie used Britney's money to sue Sam Lutfi in 2019, more than $250,000, $300,000 in fees, just to sue this one guy. And he's over here barking about the rates at Loeb and Loeb. That's basically what Sam is saying. Sam says these rates are substantially greater than the rates at Loeb and Loeb, which are capped at $945 per hour. Okay, listen, y'all. I'm not going to sit here and pretend like $945 an hour is like a reasonable rate. It is still very expensive. However, it is very hypocritical that Jamie is arguing and, losing his mind over, a $945 an hour attorney whenever he just sued Sam Lutfi for $1,100. That's $200 an hour, more than $200 an hour more, just for this one guy, right? The only reason there would be very substantial expense, and he quotes that because that is what James alleges, the only reason there would be very substantial expense would be if Jamie chooses to fight aggressively with Britney over her wish to appoint Bessemer Trust. And listen, I'm calling it now. My opinion, this is not facts, this is just an opinion, but my opinion is that Jamie is going to fight very aggressively, and he is going to try to get a firm installed that has connections either to Lou Taylor, Stonebridge Investments, or to Mitch Martin, or to Mitch's son Tyler, to some kind of connection, so where Lou Taylor and TriStar Sports will be getting some type of a kickback from this business relationship. I strongly believe that. It is not facts. That is just my opinion. That is not facts. Don't sue me for defamation. Okay, conclusion. I always love his second to last paragraphs. Okay. Oh, this is a very long conclusion. Okay. I feel like one of these is going to be my favorite paragraph just based on patterns. All right, let's go. The response, which is the document that James just wrote, right? We just read it earlier. While saying very little of substance, does reveal one thing. And what is that? That James is still looking to the past for answers. Okay, I don't really see how we got here, Sam. Let's tie the ribbon around. His backward-looking attempt to reinstate Andrew Wallet was a failure. Nevertheless, James remains focused on the prospect of Britney resuming her career, despite her stated wish not to do so, raising the issue in the response on two separate occasions, right? So Britney keeps saying she's retired. She's done working for these clowns. She's not doing it no more. Just leave her alone. And James keeps raising the issue in every single time he has the chance. First, he tried to use it against her in that Britney Leaks document. Her mental health is unstable because she doesn't want to show up at the zone for $1 million and it costs the estate, blah, blah, blah. He's just always raising it. In the response, he raised it twice. We should leave the option open for Britney to come back to work if she chooses to do so. And it's like, honestly, it's pathetic at this point. And Britney the Sagittarius, Ryan said earlier, if they were so worried about the burn rate of the estate and how fast the money is being spent, why didn't they, set up a plan for when she was ready to stop working? Why are they acting like she has to keep working into retirement? Like she's a multimillionaire. They should have set something up for her in the last 12 years. Britney simply does not share James's vision of a future in which she resumes performing and leaves the management of her estate completely to him as she did in the past. Bitch. Instead, she has nominated Bessemer Trust as an independent, extremely well qualified, that should have had a comma right there, full service, that should have a hyphen right there, financial advisor with whom she can work collaboratively to plan for her future needs, whether or not she ever chooses to perform again. I think this was like a small, like for the real Britney stans, y'all are the ones who taught me this, but I think this is a small dig at like what the rumor is that he did. And that is that he basically said, you can perform and all that, but you have to leave all this money stuff to daddy. And, as long as you do, you can get to perform and you can do whatever. And yeah, Lara Croft Online, exactly. She isn't going to work as long as her dad and TriStar are in charge. And I think that's like where we are getting. I think that's what we're getting at here. Also, there's another, excuse me. There's another side eye, like shade, whatever you want to call it here. She can work collaboratively, with whom she can work collaboratively, because don't you remember in the objection to Andrew Wallet, Sam was like, Britney has barely ever even spoken to this Andrew Wallet fool. Like, she doesn't even know him. He's like pretty much a stranger. Like, so here he's saying, it'll be better if we have Bessemer because she can work collaboratively with him. The response, James's response, gives away the game at the very end. Gives away the game. Oh, the response gives away the game. What's the game, Sam? At the very end with James' request that, yep, here it is, that the hearing, so James requested this in his document. The hearing on the litigation counsel petition should be continued that means pushed off, kicked down the road, for 4 to 6 weeks to determine if an agreement can be reached as to the structure of the conservatorship, with the onboarding of a corporate co-conservator. Yep, and I flagged that too. Oh my God, y'all, if you're watching this right now, you really should go watch the other one first because we did cover a lot of this stuff. Or I mean, stay at this point. We're in the conclusion, but it'll make more sense to you once you see the other one. So Sam says, if the court were to go along with this request to kick the can down the road another 4 to 6 weeks, the associated counsel petition would be pushed out 2 weeks past the Bessemer appointment petition to the day before Thanksgiving. One can then easily anticipate the request for further postponements due to the holiday season that will delay matters into 2021. Clearly, so he's saying, okay, yeah, let's say we do give them what they want, 4 to 6 weeks. Now we're looking at Thanksgiving, which, at least in the U.S., that's going to be, 2 weeks before Christmas. That's going to be a week before New Year's. So now we're already in 2021 and we're still asking the same damn questions. And I'm telling you, when we have this meet and confer, ain't nothing going to happen, is basically what Sam is saying, in more or less lawyer words. Clearly, James's objectives are either to filibuster, which means just talk and talk and talk so nothing gets done, the appointment of a corporate fiduciary indefinitely, so just to keep kicking the can down the road, or to dominate the entire process himself, including the selection of the fiduciary. Boom, called it myself. Yes, okay, let's read that again. Clearly, James is trying to do one of two things. Either one is to filibuster the appointment, is to push off the appointment of a corporate fiduciary into infinity and beyond, or to select that fiduciary himself. So to push it off, or either to have his own fiduciary chosen, which I can only imagine would be Stonebridge or one of their associated firms, or somebody that Mitch Martin or Tyler Martin has connections with. I guarantee you it will not be very hard for us to find that if they so do choose to try to do that. The only way to assure that Britney's voice is heard will be for her to have qualified trial lawyers, pretty much, available in order to place her on a level playing field with Jamie. There is nothing about the association of counsel, the hiring of the lawyers, in and of itself, that will result in inevitable or very substantial expense. Jamie himself holds the key to reducing or eliminating litigation in this case. Jamie Spears is the one who will be making this expensive, is what Sam is saying. He has known for months that Britney wants to bring in a corporate fiduciary and took no action to address her desire. Instead, he chose first to force an unacceptable candidate on Britney, which was Andrew Wallet, and then to delay the involvement of her legitimate candidate, which is the Bessemer Trust, for as long or as much as possible. His lawyers are always welcome to pick up the phone and discuss a resolution, but Britney should not be obligated to forego means to not have, or to give away her right to qualified lawyers as the price of the call. So basically he's saying they can pick up the phone if they want to, but in the meantime, we're going to keep the trial, the court schedule on schedule. We're going to keep the court papers going at the rate that I already said. We're not going to push this off. They want to call and get something worked out, they can, but this is James who's holding this up. For the reasons I just mentioned, Britney respectfully requests that the associated counsel petition be granted as prayed. And then he says this was from October 6, 2020. Do we have any sassy exhibits here? No. This is just his certification, or in California, I guess it's called verification. That he says it's all true under penalty of perjury, or da-da-da. All right, well, that was that. So that was sassy, coming for people's next. I'm so invested in literally at my job bathroom watching you. As soon as I got the live notification, I ran. That is so funny, and I am so excited about that level of obsession. Dennis, OCC. I wonder if they paid Ingham yet. Oh, I bet you they have paid Ingham. Depop this. James Spears is Daddy Devil in my book. He's manipulative dog that drinks too. Yep. Loki face, Sam is awesome. This whole man needs to give up. You're literally on your deathbed. Y'all, he doesn't look good. He looks a little jaundicey. I know y'all like when I start going off on what's on Daddy Spears. Melissa Wynn said, dumb question. No dumb question. Well, honestly, some people really do be asking dumb questions, but I bet you this one's not going to be dumb because you ask good questions. What does it mean to be an interested party? Why are Lynn's lawyers going to court? Are they acting on Britney's behalf or just relaying information to Lynn? Nope, that's not a dumb question. That's a good one, Melissa. I think that the reason Lynn's lawyers are going is precisely because she has been entered in as an interested party, which, like you asked, what does that mean? Interested party means that you're someone who is kind of proximal to the case, like you're kind of related to the case, and you're interested. The reason they use the word interested is because you're interested in the outcome of the case. So sometimes, let's say, like, for example, let's take it out of conservatorship. Let's say it's like a bankruptcy, right? And a bank has a mortgage on your house, but maybe someone else has a mortgage, a sub-mortgage on that house. Both of those entities would be interested parties because they're interested in the outcome of the case. So if you bring it back to conservatorship court, right, a probate court with conservatorships, anyone who has an interest in the outcome of the case could theoretically be an interested party. And since Lynn Spears is Britney Spears' mother, she definitely has interest in the outcome of the case. So the court has to kind of grant you that special permission. Other people who are interested parties, right, are Jamie Lynn Spears, who's Britney's sister and trustee, right, of one of those estates. Other interested parties are Britney's two sons, because they have an interest in whatever is left over, if anything, of this money. After their mother, were to pass away, they're going to, of course, be the inheritors. So they have an interest in the case. So, and then Lynn's lawyers are going to court. I think they're acting on Lynn's behalf as an interested party, but I really would need to look more into California law and probate law and stuff to give a more direct answer than that. Amy is trying to wear her down like the bully. Oh, Jamie is trying to wear her down like the bully he is. Yeah, and she's just getting stronger. Wait, what is my Jamie impression? Wait, Leanne, are you here? Leanne was apparently at the court. Yeah, there's a trust. So yeah, Jamie Lynn Spears is the trustee of Britney's, one of her trusts called the SJB Revocable Trust. Wait, Leanne, I want you to come on this live so you can talk about the court date. Can you request to come on? How do I can someone tell me how to invite Leanne? Wait, go live. Yeah. The Louisiana accent. Okay.
I think I did.
Okay. So,
hello?
Hey, Leanne.
Hi.
How are you? I'm not going to put my face on the camera because I look like post-apocalyptic, but I'm really
That's
glad.
okay. It's Sunday.
Oh my God, now there's a dog here. Stop, Pilot. You want to see a dog? Pilot. Hi.
Hi. I'm like waving.
That's the face y'all get. Okay, so were you at the court date?
I was.
Okay. So now that we've read these two things, can you kind of I don't know how many minutes I even have. It might be 4 minutes of this, but
okay.
Can you tell us, I really have not, I'm starting from scratch, have no idea what went on. Right now, I am up to this document. I've not read the ones where they want her to appear in court or anything like that. This is the most recent document that I've read. It's Jamie's response to, it's Sam's response to Jamie, right?
Right.
Saying that the litigation association is moot. So this is all I'm up to with these documents. So with that in mind, what happened at
court? So the hearing was, what was the date? Somebody help me. It was on Wednesday, this past Wednesday.
October 9th,
the 7th?
7th, that's right.
Yeah. Yeah, so at that point, we didn't have Sam Ingham's, I don't know if we had either document yet. I know Jamie had already filed his, but basically the whole conversation was, Sam's big argument is, I'm representing Britney. I speak on her behalf as a lawyer does.
Yes.
And I don't, the fact that Jamie's side calls that hearsay, Jamie's side was saying, Britney, him speaking on behalf of Britney, that's hearsay. It was out of court. We don't know.
Right. So just for people listening, I'm a hearsay expert now because I had to take the bar. I'm just kidding. I'm not an expert. But hearsay, a lot of people, and honestly, even me, before I learned about evidence and stuff, I didn't know what that meant. Hearsay is an out-of-court statement
offered to prove the thing that that statement is asserting. So if someone says the sky is blue outside of court and you're trying to prove that the sky is blue, you can't bring that statement in generally, but there's lots of exceptions. And one exception is the principle of agency, where you hire someone to speak for you. And that is exactly what you do with a lawyer. So it was absurd to me that they were saying that things that Britney was saying to her lawyer were allegations and hearsay. So Leanne is saying Sam called him on that.
And when he first brought it up, Cohen, who the whole time was saying, oh, I'm just so confused, Your Honor. Every time the judge would say, oh, you know, Miss Cohen, what do you have to say? She'd say, I'm confused and mystified. She was playing dumb the whole time, which was so annoying.
What was she confused and mystified about? That a lawyer can speak on behalf of their client?
To me, this is just my personal opinion. They're such a powerhouse firm. They're not used to anyone standing up against them.
I know the type.
So I think that they're just like, wait, someone's questioning me? Like, we just say what we want and we're powerhouse lawyers. I don't know. That was just my impression. But Sam Ingham was saying, I intend to speak up for Britney on many cases in the near future, many issues, and it's my understanding that as a conservatee, per the law in California, she's legally incapable, essentially cannot file a declaration because she can't speak for herself. So some media took that and spun it as to him saying she was like someone in a coma.
TMZ, yep.
Which that's not what he said. He just said, tell me if I'm wrong. Like, he was kind of playing it like, you know, I'm just following the law. And the law says she can't do a declaration. So instead, I spoke with her and relayed her thoughts into this document. So and I'm going to do it again.
I'm wondering, Leanne, did Gerald or Geraldine or whoever was there speaking on Jamie's lawyer's side, if any of them were like, well, she did file a declaration and attach it to the nomination of Bessemer.
You know, I don't know if they referenced that. I don't think their whole game was just to play dumb and act like Sam Ingham was talking like gibberish. But that is a good point. Like, she signed that. Ryan and I talked about this. It's like when it works for them, like, Britney's incompetent, but when it doesn't work for them, they want her on the stand. Like, okay.
Right. And I hope that's actually filed in court documents somehow, right? Like, that they want her to show up. Okay, so I'll get to that when I get to
I don't know if it is in court documents.
So
I just took that note, and like, that was something that they verbally said in court.
Oh, is that right? Okay. So yeah. I remember reading somewhere in the internet of things that they were saying that, you know, maybe it was a headline on a tabloid or something. It was like, oh yeah, Britney's dad and his lawyers want her to come testify in court. Like, they want to hear from Britney or something. Do you think that's where that came from the court?
Yeah, hearing? Exactly. Okay. I think it was Weil. I'd have to check my notes. I took crazy notes, but I think it was Weil who had said, you know, maybe it's best if we just have her come in. Like, it's just, they're so annoying. Their tone of voice, like, they're just condescending. And so yeah, it was just kind of an off the cuff thing that she said, it sounded like.
So did you get any sense of Judge Penny's demeanor or kind of perception or opinion on the two parties, each side? Like, were you able to read anything like from her demeanor?
I think she was very neutral.
Okay.
Or intended to come across very, you know, she was objective. She was hearing both sides. Quite a few times, I think that she understood what Sam Ingham was arguing. So she would say, oh, I agree. And then she would defer to Jamie's side. And then that's when they would say they were confused again and again and again. So it was like, it did feel like she was agreeing with Ingham a lot, but I think that's just because he was making sense. I don't necessarily know that it was like, it was kind of hard to say, but I definitely think she's open-minded enough. She was listening to both sides, trying to understand where they were both coming from. And I feel really positive about her denying the motion to seal. I really think that she's going to keep it open. And
so just to remind me, but I'll say everyone else here, what were the things that they did speak about on October 7th? Was it just the motion to seal?
Well, they continued the motion to seal, and they also the accounting, because Sam Ingham said he wants to review the accounting. He didn't have enough time. There's so many pages. It's redacted. So he's going to go through. and he needed additional time to go through it. He does plan on writing some sort of response to the accounting.
Okay, yeah. So I
so-
saw that document, I think day before yesterday. I read that one on live where he was like, we're going to object to the accounting,
Yeah.
but I need to kind of go line by line. And it's 200 pages long, and I just really can't be bothered. Like,
Right.
don't have the time to do that in the next 5 minutes. So gonna need time.
Yeah.
Okay.
And he did say, speaking of time, he mentioned that if anyone is gonna, like, Jamie's side keeps filing stuff like last minute, and it's not fair to Britney or to him that he's just put on the spot when they file stuff like at the end of the day before a hearing.
Yes.
So he's like, we have to continue it. I have to have time to do my due diligence for my client, Britney Spears.
Yeah. And what did Judge Penny have to say to that? That seems like a pretty reasonable thing to complain about on Sam's part.
I think she was kind of quiet about that part. I don't know that she ever really said anything.
Yeah,
if
because
she
I
did,
wonder,
it was probably
like,
just, that makes sense.
Like, what could she really say? I mean, if they have a deadline by which to do it, it's pretty standard practice for lawyers to just file everything at the last minute. But yeah, I mean, you're right. It does when you're looking at someone in a conservatorship where there's only really one person who can be hurt here. It's her. And you're saying, you're filing stuff, 5 minutes before. I think that one of their filings came through during court during the 2 hearings ago, like by a miracle of modern technology or whatever Sam Ingham called it. We do have a question here for you, Leanne, from Brittany Hiatus. Okay. The minute order said Judge Penny ordered them to file stuff later this October. What is that about? Does that ring a bell?
So, yes, they established a briefing schedule. So, essentially, and this was a lot of where the confusion was coming in on Cohen's side.
Okay. Oh, okay.
The judge wants them. I am just confused and mystified. Like, I'm not kidding when that's how she said it. It was like I was watching a movie. Like, lawyers don't say that. I don't know. It was weird. I haven't been in court very much, so maybe
she seems to be pretty mystified about how to format a goddamn court document, too. She starts sections with the number 2 and spaces out commas and periods and question marks and quotes.
I think we should just throw it out. The grammar is just too bad. It's got to go.
$1,000 an hour, you'd think she'd know how to put a quotation mark somewhere.
Seriously.
Sorry, I'm so distracting.
Oh, no, the question. Wait, what was the question? Oh, so they have this briefing schedule, and basically the judge kind of wants, this part was slightly confusing, but the judge wants Jamie's side to write a briefing, which I don't fully know what a briefing is, just like a document, like a declaration. I mean, I don't know what that is, but about like the hearsay stuff.
Okay.
That
is it possible she said just a brief? Or a memo. It's whatever it is. If she wants them, is it that she wants them to say, like, what do you make your argument? What do you mean hearsay? How is it hearsay?
Right.
Okay.
And that's where they were playing dumb. She's like, I want you to make your argument. And they're like, well, how can we say, if we don't know if in future documents what will be hearsay? And it was just a lot of like bullshit. But they have to file something. There's that first date in the minute order. They have to file by then. And then Ingham can respond by a certain date. And then they can respond one more time. And then the judge will review it, and we'll also discuss that on November 10th. Just add it to the list.
I feel like there's just no way that this is all going to be able to happen on November 10th.
No. I don't think so. It's because it's at 1:30, and we know in the past that we've had to continue just because we ran out of time. Like, the probate court closes at like 4.
And someone told me that the hearings where there's nothing else on Judge Penny's docket are on Wednesdays. And then other hearings, like if they're on a Tuesday or something, then there's other things going on her docket that day. And I'm pretty sure that November 10th is not a Wednesday. So that makes me even more nervous.
It's a Tuesday.
I mean, that's just rumors. Yeah. I don't know if that's real. I forgot where I heard
No, I think you're right. I think it might be opposite, though. I think it might be Wednesdays that she usually has others.
Oh.
Because when I went in August, I went to an accounting hearing that was really boring, but there were other people in the courtroom, and we did all the cases together, and it was a Wednesday.
Okay. So maybe
Tuesday's just Britney, but even still, it just seems like it's going to be a long day.
So does anyone else have any other questions for Leanne? Otherwise, I'll just keep asking stuff. So let me think. What was the other thing? So they were going to talk. Okay. So did they talk at all about the motion to seal, like in substance? Like, it's moot? Like, did they start making the arguments?
They did at one point say because they withdrew the wallet petition that it was a moot point.
Mm-hmm.
But Ingham said, well, it's still applicable to like everything else. So just because you withdrew that, like
Right.
that
I was
petition
thinking,
itself.
I was thinking the same argument that Geraldine actually was thinking the same argument that Jamie's lawyers made, which was if it's a motion to seal on, like, the specific name of the motion to seal was like motion to seal, whatever related to the appointment of Andrew Wallet as co-conservator, blah, blah, blah. And I just immediately thought, okay, well, if that underlying document doesn't exist anymore, then why do we need a motion to seal that underlying document and everything related to it? But then Kevin, Free Britney LA, said, well, that was something they actually talked about in court, where Sam Ingham said, yeah, maybe for this particular Andrew Wallet, but we're still about to talk about appointing a conservator, and we don't want that to be sealed. And is that something is that how you understood them to
That's
be?
exactly, yeah. Kevin hit the nail on the head. That's how I took it. It was like, okay, in this particular instance, we throw it out because it's moot based on that specific issue. But then next week, they're just going to file another motion to seal with another document that they send in. And they're going to, we want the transparency. Moreover, it's more of a broad issue. And that was similar to his argument about the hearsay. It's like, if you're going to just keep saying it's hearsay, let's nip it in the bud.
So
let's say,
that's right. So at any time, I get it now. Okay. So Sam is saying, at any time, I might need to speak on Britney's behalf. And I might need to say, Britney says X, Y, Z, LMNOP. And if every time I do that, this hen house says, hearsay, 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 I need you eventually to tell me, am I allowed to speak on the behalf of my client or am I not? And then Geraldine, or Cohen rather, was saying she was mystified because she wouldn't be able to predict what things that she might that might come up that she would have hearsay, but she can actually, and she's not mystified because it isn't specific sentences or specific declarations that Sam Ingham is trying to bring in or keep out. He's trying to say, in general, do I have the authority to talk for my client?
Right.
I see.
It was point blank. Like, I represent her as I have for 12 years. It's my responsibility to speak on her behalf. So how else am I supposed to get her point across if she legally is incapacitated as far as she's not able to sign legal documents per the state of California, being a conservative.
And you know what else, Leanne? Another thing is, Geraldine and Gerald have no problem speaking on behalf of Jamie. Every single thing that they file says, Mr. Spears believes it is not in Britney's best interest. Mr. Spears believes blah, blah, blah. Mr. Spears has made the decision. Mr. Spears says, Mr. Spears thinks blah, blah, blah. So they don't think it's hearsay when they do it. I don't ever see them filing declarations of James that are signed by him. I mean, I've seen a few over the years.
Yeah, it's more rare. Yeah. Again, it's the hypocrisy. When it works for them, it's great, and otherwise, like, Britney's not allowed to defend herself.
You would honestly be astonished at how often this happens in litigation, though. Like, I think a lot of us in the Free Britney movement, and me included, and I've been to law school, okay, like, have this, like, benefit of the doubt to other humans that they would at least, like, not boldface lie. Like, we kind of, like, put things, like, we put these expectations on other people, and, like, at the very least, they wouldn't, insert thing, right? Like, lie on the record under penalty of perjury, knowing the whole world is going to see it. Surely they wouldn't do that. And then they do. And it's like, what's really blowing my mind in my very short tenure in the legal profession is this happens in regular cases too, where it's like people will do stuff, and it blows your mind. And then whenever you try to do it to them, they're mystified and astonished and confused. And it's like, well, I'm taking this play out of your book.
Exactly. Which I loved. Sam put that in. Was it this document?
What?
Like taking a page. No, he didn't say something. Taking a page out of their book or leveling the playing field or something.
Oh yeah, he definitely said leveling the playing field. Let me see. Because
I love the sense.
Yeah, it's this right here. He says the only way to assure that Britney's voice is heard will be for her to have qualified litigation counsel, so like trial lawyers, in order to place her on a level playing field with James. Yeah. Because they're going to keep pulling out all the stops.
Yeah. They're not going to, and that's the thing. I feel like do they not realize that, like, they're done? Like, we have them kind of, we know too much. Like, this isn't going away.
Yeah.
They can't continue to lie. Like, things that worked in the past for them are not going to work now.
And they're going to continue to be mystified and astonished because they have not had to explain themselves or give their legal logic, their reasoning. It has not had to withstand the scrutiny, right? Like, I do think, and this is just like a personal observation, like, this is not facts, this is just anecdotal. I do think that people get in the legal, every profession, but the legal profession included, they kind of get good at their one thing and they get really, you know, an inch wide and a mile deep. And then all of this stuff that you had to, like, stay on your toes when you're a young trial lawyer, like a public defender or even a prosecutor,
Right.
or a law student or someone who's like teaching clinics or whatever. It's like you have to know how to, like, you have to be flexible, adaptable. And I think, like, when they're finally say, like, wait, hold on, how is that hearsay exactly? And they have to make a legal argument. It's like, oh shit, like, it's been 42 years. Let me dust off the cobwebs. Like, what is hearsay?
It did kind of feel like that. Like, they're just not used to having to explain themselves. Like, they just do what they want. The judge rubber stamps it. We move on.
Did
Like,
that feel kind of like good, like, to see like them have to squirm a little bit?
It was ridiculous. By the fourth time she said she was confused, like, we were all shifting in our seats, like, looking around. You know, I'm looking at, like, Tess and Babs from Brittany's Graham. We're all like, what? Is this woman really saying this again?
So a lot of times I'm sitting in court and I am confused. I don't know what's going on. Whenever, like, I mean, as a person in court, I've never litigated in court. I mean, like, you know, just from sitting in there and watching it.
Right.
Was it obvious to you what the judge was asking, or do you think it's reasonable that she was confused?
Well, that's why I try in everything to be pretty objective. So I'm like, okay, let's just imagine I don't know what I know and I'm her. I'm not a lawyer, and I understood exactly what Ingham was saying. At one point, I seriously wanted to raise my hand and be like, can I translate for them? Because I understand they're both speaking a different language, but they're both, like,
and
they just weren't understanding each other.
I don't know. I'm kind of cynical, but I do feel like if you saw that, and like you said, you're not a lawyer, Judge Penny, who is not only a lawyer, but is a judge, must at least see it. I hope. I'm cynical, so I'm like, maybe not. But I really hope. So we have another question. BJ, okay, BJ, wait until you read the declaration about Jamie's document being late. Okay. And,
and that's, you know, they brought that up in the hearing at the very end. They were like, we just want to make sure this document, like, they explained the whole thing about how it was late, technical difficulties, blah, blah, blah. Yeah, you'll read the document, you'll get all the details.
And was the thing that was late the accounting, or was it something else?
It was the opposition to the litigators, I believe.
Right, okay. That he called a response that was supposed to be an objection.
And it was supposed to be, he had to file it by Friday the 2nd, and for whatever reason, it didn't go through until Monday. So they were panicked that it wasn't going to count. And the judge was kind of like, well, did we receive it? And this was Wednesday at that point. And she's like, well, yeah, you guys got it now. And the judge was like, okay, as long as we have it, that's fine. And Ingham was, like, unfazed. He's like, oh, yeah, I got it in a timely fashion. I've already fashioned a response. Like, we already knew he was about to drop his response because he had seen Jamie's whatever. I can't even keep track of what they're calling these documents.
Well, and it's really hard to keep track too, because what they were supposed to be were, like, Jamie was supposed to file, if he had any, objections, and then to that Sam was supposed to file a response. But instead of objections, Jamie filed a reply, which is slightly different, right? Like, legal mechanism. And then instead of a response, instead of a response, Sam filed a reply. So even if they were using the right names, it would have been confusing. But the fact that we have 7-8 documents in a 4-day span, like, it's super hard to keep up with. That's why I keep being like, okay, oh shoot, we only have 1 minute and 11 seconds remaining.
Oh, okay.
Okay.
Well, we'll catch up after this Wednesday hearing, maybe.
Yeah. We can do another little impromptu live, or maybe like an actual planned one, even.
Okay.
Chaotic. Thank you so much for coming on here. It actually helps me to put the pieces together better, and I definitely think that it helps other people too, because otherwise, like, I would just be sitting here going, I don't know. Leanne had said something, Meaner said
teamwork,
something. I don't
baby.
remember. Yeah,
no, it's
so helpful. Okay, Leanne, well, have a good night, and I'll talk to all y'all later. Bye. See y'all later. Bye.